In this episode, Auditor Autistic Audits heads to the BBC building to peacefully film from a public space. But things spiral fast. Two completely unhinged officers arrive, rattling off nonsense about a morning briefing and claiming he matches the description of a wanted person. With zero proper investigation or lawful grounds, they demand his details and, when he stands his ground, they arrest him. Thankfully, Autistic Audits teams up with HNK solicitors, takes the matter to court, and wins the lawsuit against these super bad officers.
How are you doing? You alright?
Yeah, I'm not too bad.
What are you up to?
Can I ask you why you're engaged in it?
Stop there a minute.
Why?
I'm just trying to identify who you are because you've got your face covered and you've... What's your name, please, sir?
I don't have to give you my name.
Okay, well, at this moment in time, we believe that you might well be wanted. Okay. Well, we'll cross that bridge in a minute once we've confirmed it. So that's why we need to identify who you are. It's all right. We'll do it another way. Just bear with us a second.
You start with your first name, please, sir.
Don't believe I have to provide your name.
Okay. Well, I believe that you're wanted, right? Okay. Just by your description alone, right? So I believe that you're wanted off a briefing that I've received today, right? So we can do it one or two ways.
Wanted for what?
Well, wanted for an offence.
What offence?
Well, wanted for an offence of harassment, actually. So I need to check you out in order to see A, if it is you, or B, if it isn't you, right? And if it isn't you, I'll bid you good day and off you go.
From the moment the officer opens his mouth, the entire approach feels off balance. Instead of presenting clear facts, he leans on a vague morning briefing and insists the auditor resembles some wanted individual. But here's the issue. There's no proper description, no reference to a specific crime, not even a credible reason to link this person to wrongdoing. What we're left with is not fact-based policing but a pressure tactic disguised as procedure. When the auditor exercises his right to withhold his personal details, the officer doesn't back down. Instead, he escalates. He makes the troubling remark, "If it's not you, I'll let you go." That single statement reveals the deeper problem. It treats identity as a checkpoint test, as if freedom is something to be earned by proving innocence. This is not how rights are supposed to work. In the UK, liberty isn't granted on the basis of guesswork or hunches. The law requires reasonable, articulable grounds before police can demand information, not half-remembered briefings or instinct alone. By framing suspicion as enough, the officer blurs the line between lawful policing and fishing for compliance, an approach that risks undermining public trust in the very powers meant to protect.
So if we start with your first name, or are we going to have to get a fingerprint scanner down here and find out who you are, or take you down to custody to try and identify you because you refuse to give me details?
I haven't committed an offence.
Okay, so if you haven't committed any offences, can I start with your first name, please, sir?
I don't need to give you my first name.
Okay, well, I believe you to be Christopher Green, and I'm detaining you currently.
I am not Christopher Green.
Right, okay,
that's fine.
that's fine, but you're currently being detained up until the point that I can establish who you are. You're refusing to give me some details, so I need to establish who you are.
Please ask you to identify yourself?
Yeah, I'm PC 17768 Neil Williams.
And you, please?
Sergeant 15563.
Thank you.
Right,
which station?
Can we make it nice and easy for us and start giving just your first name, please?
Can I ask you which station you're from?
Yeah, I work at Withenshaw Police Station, work part of the X Department and part of the Transport Unit for Great Manchester Police.
Thank you.
Okay?
Yep.
So we're going to start with your name then, please. And if there's nothing wrong, then we'll send you on your way.
When the officer suddenly blurts out, "I believe you to be Christopher Green," the encounter takes a troubling turn. The auditor immediately and calmly denies being that person, but the very exchange reveals what's really happening here. This isn't a careful effort to confirm the identity of a wanted suspect, it's an officer asserting control because he feels his authority is being questioned. What makes it worse is that the auditor had shown no behavior that would justify suspicion. He wasn't evasive, he wasn't acting aggressively, and he certainly wasn't threatening. His only stance was refusing to hand over his name without proper legal grounds. And in the UK, that isn't suspicious behavior. It's a legal right. Exercising a right doesn't turn a citizen into a suspect. But the most alarming part of this encounter is the officer's decision to publicly announce a full name, Christopher Green, in connection with a potential wanted person. Under the UK's GDPR and the Data Protection Act 2018, personal data must be handled with extreme care, especially by law enforcement. Throwing out a name in public without confirmation not only undermines privacy, it risks damaging reputations. If the auditor truly isn't Christopher Green, then two people suffer harm. The auditor gets wrongly tied to criminal suspicion in front of others, and the real Christopher Green, if such a person even exists, has his name dragged into the open unnecessarily. It's reckless, potentially defamatory, and completely irrelevant to establishing any lawful grounds for a stop.
It's not Christopher Green.
Okay.
100 Alpha.
And what is your name, please? And have you got anything to identify yourself?
I don't believe I have to answer these questions.
Right. You don't believe that you have to add, right, okay. Well, I believe you to be wanted, right? So make it easy for us. Give us your details, identify yourself, show me some identification.
I don't believe I have to identify myself.
Well, you do.
We could arrest you, take you to custody and put you on a live scan machine. There's a necessity, if you're not giving your name and address, for us to verify who you are if we believe you to be wanted from the information we've got. So you can
I don't have to do that. You've not provided me with any grounds for arrest.
Right, take your hands out your pocket so I can see them. I need to identify you. I'm trying to make it easy for you here, sir. So what I want,
I'm not in any threat to you.
No,
guys.
not at all.
No, I'm not.
You had your hands in your pockets, and I don't know who you are.
Even after stopping and detaining someone in broad daylight, the officer still hasn't laid out a single concrete reason. There's no mention of a clear offense, no reference to actual evidence, just the repeated fallback that the auditor matches a description from some earlier briefing. That's not a lawful basis, that's a placeholder excuse. When the auditor does the logical thing and asks the direct legal question, "What specific offense do you suspect me of?" the officer doesn't answer. Instead, he pivots, suddenly focusing on the auditor's hands resting in his coat pockets. It's a classic deflection. He knows the legal ground beneath him is crumbling, so rather than justify the stop, he creates a new concern out of thin air. The message being sent is troubling. Calm posture and normal body language are now treated as suspicious behavior. By shifting the narrative, the officer tries to turn something harmless into justification for detention. But the slip comes when he admits, once again, "I don't know who you are." That statement cuts to the core problem. This isn't a detention based on criminal behavior, it's a detention based on unfamiliarity. The officer isn't acting on proof of wrongdoing, he's acting because he doesn't recognize the person in front of him. That's not law enforcement guided by evidence, that's an abuse of discretion wrapped in authority. And it leaves the impression that the goal was never about solving a crime, but about forcing compliance.
Up until the point that you identify yourself, make it easy for us, and if it isn't you, and I can establish who you are, and I can clearly identify you, then I'll send you on your way. Right, okay. But by you being obstructive at the moment...
I'm not being obstructive.
Well, you are, because you're refusing to provide some details.
No, because I don't believe lawfully that I have to give you those details because I haven't committed any offence of harassment. I'm sorry.
Right, okay. Well, I believe you to be wanted, so I want you to. I need you to identify yourself in order for me to make those inquiries. And once I make those inquiries and find out that you are either wanted or you're free to go, I will then send you on your way. Okay. Oh, no, don't. No. Excuse me. I'm speaking.
You've asked me whether I'm Christopher Green, and I've said I'm not Christopher Green.
Right, and all I'll say to you is, right, identify yourself, because
stop giving me orders.
I'm the police here.
Speak to me respectfully.
I have done. I've tried.
Speak to me respectfully.
What I'll say to you is, you're not going anywhere up until the point that I can clearly identify you. Okay.
Right, but please continue to speak to me respectfully. Okay.
So what's your name, please?
To speak to you always
start
respectfully.
With your name, please.
Throughout the encounter, the auditor remains steady, calm, respectful, and firm about his rights. He makes it clear that he hasn't committed any crime and that, under the law, he's not obliged to hand over identification without proper grounds. That's a straightforward position, entirely within the protections every citizen is afforded, but instead of responding with professionalism, the officer snaps. He raises his voice, shouting, "No, I'm the police here," as if repeating his title somehow transforms shaky conduct into lawful authority. That outburst does more than just break composure, it exposes the truth of the moment. The officer isn't anchored in law, he's grasping for control. When a figure of authority starts to lose grip on the legal foundation of their actions, the fallback is often aggression. And that's exactly what we see here. The shouting isn't about clarity, it's about dominance. By projecting volume and hostility, the officer attempts to mask the absence of lawful justification with intimidation. This aggressive posture is not accidental. It's a deliberate tactic meant to unsettle the auditor, to pressure him into submission through fear rather than reason. Yet, in doing so, the officer highlights the weakness of his case. Because when authority is secure in the law, it doesn't need to shout. It simply explains.
I'm not giving you my name.
Right, have you got any ID on you?
I'm not. I don't have to do this.
The problem is,
Why-
we suspect you of an offence.
Why do you, sorry mate, why do you believe that you don't have to do this?
Because I don't believe I've committed a criminal offence.
Right, okay. Well then make it easy for me, sir, right?
I don't have to make anything easy for
Yeah,
you.
you do, unfortunately.
No, I don't.
Why aren't you being so obstructive? If you've not committed any offence, we can check your details and then you
I
can
don't have to discuss anything with you.
Why are you trying to avoid it?
I'm not trying to avoid anything.
Because it's going to be a long process for you if we have to take you to custody and put you on one of them live scan machines to find out who you are.
Well,
So it'll be a
it
lot
sounds...
straightforward if you just give us your details. We can check if you want or not. If you're not, absolutely fine, which is what you're saying.
That's not what I'm saying. I'm saying I'm not Christopher Green, and I'm saying I've not committed
Right,
offensive
so
harassment.
who are you
okay?
then?
I've just told you I don't believe that I have to give you that information.
At no point is the auditor obstructive. He isn't raising his voice, he isn't being evasive, he's simply and calmly asserting his legal right not to hand over personal details without a clear and lawful basis. That's not defiance, that's the very definition of a citizen exercising the protections the police themselves are bound to respect. But instead of acknowledging those rights, the officer pivots to intimidation. He warns that if the auditor refuses, he'll be dragged through an unnecessary custody process. This is no longer about investigating crime or protecting the public. It's about punishing someone for noncompliance, a threat of inconvenience dressed up as procedure. The casual reference to the live scan machine exposes what's really driving the officer's actions. It isn't evidence, suspicion, or law, it's pressure. The threat of wasted time, hassle, and humiliation is being used as a substitute for the legal grounds that simply don't exist. That is not policing by principle, it's policing by coercion. And here's the irony. By resorting to threats instead of clear justification, the officer ends up proving the auditor's point in real time. When the public understands their rights, and an officer responds by trying to intimidate rather than explain, it shows a failure not of the citizen, but of training, culture, and accountability within the force. Good policing doesn't fear rights. It works within them.
And if I do, then I can give it to a desk sergeant, or I can give it to a judge.
Please, so I can see exactly who you are.
No.
Right, I'm going to let go of your arm now, yeah? Okay. What I don't want you to do is I don't want you to be putting your hands in your pockets.
Promise
right?
you I won't do that.
Okay, because I need to be satisfied that you've not got something that can harm me or anyone else.
I promise you there's nothing in my pockets that could harm you.
It is, isn't it? Boss.
Do you want to go and have a look at that picture? I'll stay here.
So guys, it looks like I'm going to be arrested here. Could you turn this off?
Right, you're under arrest on suspicion of harassment.
According to the evidence, unlawfully arrested. I've now passed the case on to HNK, and they are currently considering all of the information before they either accept or reject the case, and I'll let you know what happens there, guys.
The officer continues pressing, even as the situation teeters on the edge of escalation. He insists, "Stand by, so I can see exactly who you are. Don't put your hands in your pockets," claiming it's for safety. The auditor, calm as ever, reassures him that there's nothing in his coat that could cause harm. Yet, despite this steady demeanor, the officer presses forward. Within moments, the words come, "You're under arrest on suspicion of harassment." This was the breaking point, and it marked the lowest moment in a string of poor decisions. After failing to provide any lawful grounds and leaning on nothing more than vague descriptions and pressure tactics, the officer resorted to arrest. No evidence of a crime, no verified suspicion, just an abuse of authority. It was the very definition of overreach, but the story didn't end there. The auditor later confirmed that HNK solicitors took on the case, and after reviewing the facts, they supported his claim. Weeks later, he publicly shared the outcome. He won. That victory was more than personal. It was a strong reminder that unlawful policing carries consequences and that rights, when defended, can and do stand up in court. The wider story makes the pattern clear. The entire incident began with the auditor peacefully filming outside the BBC building, an activity fully within his rights. 2 officers arrived, escalated almost immediately, and relied on nothing more than a vague morning briefing to justify their actions. The lead officer wasted no time demanding a name, and when the auditor lawfully refused, the situation unraveled. Instead of providing articulable suspicion, the officer declared the auditor to be Christopher Green, even saying the name out loud in public. That rash decision raised serious concerns, not just about mistaken identity but about breaches of data protection law. Naming someone as a suspect without confirmation isn't only careless, it risks harming 2 reputations at once. The more the auditor pushed for clarity, the less the officers had to offer. The lead officer erupted with the now infamous, "No, I'm the police here." A telling outburst that revealed the encounter was never about law but about control. And when legal justification was nowhere to be found, intimidation filled the gap. The second officer even warned that refusal would mean a long, uncomfortable custody process, an attempt to scare compliance rather than uphold justice. In the end, they carried out the arrest. But without evidence, without lawful grounds, and without respect for the rights at play, the decision collapsed under scrutiny. Court vindicated the auditor, proving that the law cannot be bent to fit authorities' frustration. This case shines a spotlight on everything that goes wrong when vague suspicion is treated as fact. Rights were ignored, aggression stood in for professionalism, and ultimately taxpayers paid the price through legal claims that should never have been necessary. Authority without accountability isn't policing, it's abuse. The outcome serves as a reminder that the law is designed to protect citizens, not convenience officers. True policing doesn't fear rights, it respects them. And until that culture shifts, these lessons will continue to be learned the hard way. That wraps up today's coverage. If you found this breakdown valuable, don't forget to like, comment, and subscribe for more independent analysis. And make sure to support Autistic Audit by checking out his channel, linked in the description. His work continues to highlight these issues in real time. Thanks for watching. This was Rate the Audit, and I'll see you in the next one.